to this policy seminar organized between the Migration Policy Center at the EUI here in Florence and CEPS. This seminar falls within the scope of the ASILE Horizon 2020 project, a project funded by the EU, which look at asylum governance systems around the world in light of the Global Compact on Refugees. And we pay special attention also to the role of the European Union. And I'm the project coordinator of ASILE. I'm a senior research fellow at CEPS and a visiting also fellow here at the MPC. And I'm very happy and grateful to have this occasion to chair this policy seminar, which is actually part of a wider training school that we've been having in person in Florence. It's been fascinating to meet again people face to face and really feel this energy of interactions and socialize in a completely different way. So the ASILE policy webinar title is Externalizing EU Migration Management Policies, Responsibility and Justice for Human Rights and Refugee Protection Violations. Now, the ASILE project, in addition to exploring comparatively how different countries around the world are dealing with large-scale refugee movements, we also critically examine the role of the EU and the current conversation and debate on the reform of the common European asylum system and more generally migration policy. And we've seen, and this has been noticed in the academic literature already for some time, how one of the key characteristics or features of the EU's involvement has been very much engaging in externalization. What do we mean by externalization? We mean migration management policies that get into third country cooperation, that get into foreign affairs and international relations, where those third countries are positioned or given a very specific role in the containment of mobility. Now, there's been a whole exploration in the academic literature about containment policies, and we've been exploring this during this week in the training school. And particularly in this external dimension, these containment policies translate into very specific practices, be it interceptions at sea, pullback policies, capacity building on migration management, border surveillance, and the criminalization of human smuggling, to name a few. Now, the EU uses different instruments in this regard, including funds, which come along a number of actors as well, a very complex, actor landscape, which include transnational, international, national, and local actors with different roles and functions, which raises the question of responsibility. What happens when those policies actually do not meet their objectives and actually may endanger the rule of law or human rights protections in those countries and the rights of people on the move? Who is responsible? How do we allocate and attribute responsibility and ensure accountability of those policies, which at the end is fundamental in the legitimacy of these same policies? Now, in today's seminar, we want to look at this, but also the mobility angle. There's been a proliferation of so-called complementary pathways instruments in the form of emergency transit mechanisms, for example, the one in Niger, humanitarian corridors, and private and community sponsorships. Now, we want to raise the question, do these instruments really provide a different way to look at this conversation? Do they really provide a solution to address some of the dilemmas raised by containment policies? Can we really see them separate from a wider containment agenda of the EU? And what about, again here, responsibility and remedies of those who are part of those instruments in terms of having access to those instruments and so forth? So a whole series of questions, and we have a wonderful panel of speakers. I'm really glad, and we are very happy that most of them have made it in person in Florence and are here with us. We have a 4 speakers panel, starting with Eugenio Ambrosi. He is working at the International Organization of Migration. We know each other for a very long time, and he's really someone who has a very in-depth knowledge, not only of migration phenomenon in general, but also policy making. He has enormous experience, and he's now in Geneva working on these issues. We will then move to Tamás Molnár, the European Union Agency for Fundamental Rights. Also, Tamás has a long time, really long record as an expert, really extremely knowledgeable on questions of legal dimension of EU migration and asylum policies. And the FRA, of course, is playing a very fundamental role in precisely doing this, questions of impacts of policies on human rights more generally. Then we will have Inma Vázquez, Médecins Sans Frontières, MSF, Brussels, very active, really long track, someone who knows also very much in detail policy-making processes and the key questions. And MSF has recently also published a report on complementary pathways. And then we will have Cecilia Andersen. The Danish Refugee Council actually is a partner in the ASILE network. ASILE is not only a network of academic institutions, universities, but we also count with the DRC, who is playing a very also active role in the ASILE project. And Cecilia also is, a very key member in our network. So let's start with the conversation. For the people who are joining us web streamed, please feel free to write your questions or comments in the YouTube option. I will be receiving those questions and bringing it back, hopefully, to the panel at the best I can. So let's start with Eugenio. Eugenio, you have the floor.
Thank you. Thank you, Sergio, and thank you for the invitation. It's a pleasure not only to be here participating in this policy seminar, but also to be in Florence, if I have to be honest. I'm Italian and part of my family comes from here. So it's a particular pleasure to be back in this city. I haven't followed the discussion in the previous days and the work that the overall seminar has carried forward. So I might be mentioning some aspects that have been touched upon before already, but there are a few points that I want to make on the specific issue of externalization, as well as some comments or inputs on some of the key questions that the session brief had presented. I think we need to step back a second before we start talking specifically about externalization and complementary pathways and the other issue that are raised in this policy seminar. And we need to step back to the fact that it is now several years that we see the protection space shrinking steadily and dramatically, I would say. And when I say protection space, I don't mean only refugee and asylum seeker protection and international protection based on 51, 60, Convention 66 Protocol, etc., but protection in general of all the category of people on the move that require some sort of protection. That might be asylum, might be other type of protection, temporary or otherwise. This is a trend that has started years ago. You might remember, at least some of you, the Nauru operation, where Australia started diverting boats trying to reach Australia to Nauru and do an off-site processing system that created all sorts of problems in any respect, not just violation of human rights, but also in terms of actually efficacy of the system. That experience was at the time, first of all, was far away. It was in Australia and the Pacific Islands. So here in Europe, we didn't really mind that much. But also was a sort of pariah type of experience, was a type of response that nobody in other parts of the world felt like openly supporting or using as a model. This has changed over the last few years, especially in EU. And in fact, and Sergio might remember this, in the last few years, several times in Brussels, the Nauru model as an inspiration has been mentioned by policymakers. But beside the mentioning as an inspiration, this is a model that, in fact, has started to take hold more and more in Europe, among EU member states, but also in other parts of the world, what the United States is doing now with Mexico and the rest of Central and South America, and has been doing before. Previous administration as well as current administration is pretty much the same. Now, how did we get to this point? Of course, it didn't happen one day from another, but I think part of the problem is that in certain regions of the world, and the EU is a clear example of that, in my view. We have looked at migration policy with an obsession to contain arrival, reduce it, and possibly in some EU country, this is the wish, stop it altogether. And every policy response has been guided by this obsession. We need to stop people to arrive. Doesn't matter if are millions or a few hundreds, we got to stop them to arrive. If by any chance they manage to arrive, then the second stage of the response is, of course, return at any cost, whatever the circumstances due to which these people moved. And I say this as an obsession on purpose, because in my view, this is an obsession. It's not driven by any factual consideration, logical consideration, efficiency consideration. It's just a dogma. People must not arrive. Few examples just to prove the point. Well, first of all, I think the first time that, not so explicitly, but de facto this principle was applied was with the EU-Turkey statement, where basically what it was said was the 28, at the time still, 28 EU member states could not afford to receive and accommodate and properly care for X millions of Syrians arriving. But if you give 3 billion euro to Turkey, they can. Which even logically doesn't make sense. But anyway, this was de facto the approach. So we keep them there, they don't arrive here, we are all happy here, we give you money, you take care of them, or we hope you do. That's a very good example. To come to very recent days, before the war in Ukraine, I think it was January or December last year, January this year, there was the crisis at the Belarus-Poland border, where you had slightly more than 1,000 migrants that were pushed, whatever the reason, mostly Iraqi, by the way, they were pushed over the border and trying to enter Poland, 1,200 at the peak, which would be an insignificant number for any location in the world. Still, the response was first, and this was a public statement by the government, if they managed to cross the border into Poland, that would constitute an existential threat for the state. 1,200 people, an existential threat. And then in order to avoid that, the army was deployed at the border, and at a certain point there were more armies than refugees or migrants on the other side. So if this is not an obsession to avoid people entering, I don't know how else to call it. This is also based, I think, on a concept of sovereignty that has over time been either misinterpreted or in any case twisted around, whereby most states apply the sovereignty principle without any regard with international obligation, as if the two things are delinked, as if since I'm sovereign in my own country, then I can do whatever I want, and I don't have to follow international standard, apply international law, etc., if that is not convenient to me. Some EU countries have been discussing or even trying to change their own constitution to make sure that national law takes precedence over either EU or international law, which means that at that point I would have the freedom to say, well, this international treaty doesn't apply, this convention on refugees or whatever else that has to do with human rights doesn't apply because my sovereignty comes first and foremost. That is obviously a misinterpretation of, and I think is a willing misinterpretation of the facts and of the basic principle of international law. And this goes along, I think, and is accompanied by a misinterpretation of and a misconcept of the concept of solidarity and sharing of responsibility, which is another concept that is fundamental, first of all, in refugee law, because the 51 Convention foresees the burden sharing principle. but is a founding principle of the EU, which of course is one of the founding principles that the EU has very frequently forgotten in the last few years. Why I say that these two things go together? Because right now the principle of solidarity and shared responsibility is applied, especially by the country in the north, the EU, but not only, in a unilateral way. Solidarity means that now you, Rwanda, other country, especially in Africa, have to help me, have to take care of my problem. You have to be responsible with me of handling the flow that are arriving on my territory. This is a skewed application of the principle of solidarity because it's unilateral, it's one way. You got to be responsible, and my only responsibility is eventually to give you some money, a lot or a little. But anyway, that's where things stops as far as my responsibility. Your responsibility is take care of my problem. And it's interesting because we are asking country in the southern hemisphere of the world to share a burden for some, but in any case, to share the responsibility of a situation that we ourselves in Europe do not have, neither the willingness nor the courage to share among ourselves. Some might say, well, this didn't happen for the Ukrainian refugees. There has been a display of solidarity. There has been a sharing of responsibility among EU countries to mutually support each other in facing the large influx. And I would say, yes, it's true, and it's welcome, especially for the Ukrainian refugees. It's a very welcome move. But it's the exception that confirms the rule in many ways. First of all, because as you know, after 20 years from being drafted, the TPD, the Temporary Protection Directive, has been put into action, but it applies only for Ukrainian national fleeing the war. It doesn't apply to any other nationality fleeing the same war. And Ukraine has had a very large number of African students, for example, that are fleeing the same bombs. For them, TPD doesn't apply. For the Ukrainian, yes. So yes, of course, very welcome for the Ukrainian and for that situation. But that proves that the principle of sharing responsibility of a crisis situation that entails large mobility of people is obviously either misinterpreted or misused. And here we come to the specific issue of externalization, which could be answered very briefly in saying, in my view, is wrong from any point of view. It's simply something that shouldn't happen, full stop. For various reasons, it shouldn't happen. The first, because it takes the real accountability for states that are receiving flow of people, be them migrant or refugees, it takes the accountability of their action completely away. You strike an agreement with country X, your only obligation is to possibly, in a human fashion, bring people to this country X. What happens is their problem. And some of these agreements are either have been done or are being discussed without, to my knowledge, without any consideration of how the system and the due process in that country works. Is it according to international standard? First of all, it did exist, due process. It is according to international standard. How are the conditions of acceptance and maintenance of this group of people? Because if you send a plane load of asylum seeker, let's just make a wild example, from London to Kigali, 300 people arrive, they're not going to be processed in a day. So how is the system works? Is according to international standard? Is it not? and how the country, not just the government, but the country is or is not able to cope with that situation, depending on the number of people you send. I still find it flabbergasting that a European country cannot cope with 2,000 people arriving, but thinks that Rwanda or Burundi or Tunisia can. I don't understand how that is logically possible. And yet, this is the driving principle. So the first problem with the externalization is the total lack of accountability that goes along with the total lack of any quote unquote conditionality. And I use the word conditionality because in the EU, especially in the Commission, is a word that is particularly liked. Not always for the right reason, but anyway. Without any conditionality on you need to adhere to this standard for the treatment of these people. The other aspect is that externalization is not just the result of agreement. UK, Rwanda, apparently Denmark is also discussing or thinking or negotiating something similar, but is very often a de facto situation. Good example of that, and I think Sergio knows what I mean, Libya. There is no agreement of externalization of the flow with Libya, but we basically are paying, well, we basically are paying some sort of Libyan institution to make sure, to the maximum possible extent, that people don't get to Europe. And there is a very clear example of the lack of accountability that I just mentioned before, because there we do that with absolute total disregard of the condition, the treatment, and the overall situation of the country. Libya has been declared by us, IOM, by UNHCR, by the UN, by I think everybody that has a minimum of conscience, as a place where people should not be returned. And yet, the policy of the EU is with the legalistic explanation, which is the Coast Guard operates in Libyan water, so they don't return people. They are still, the Libyan water are part of Libyan territory, so they're just controlling their territory. We know we return people in the condition that we all know what they are, and we don't need to get into detail. That is also externalization. The difference is even worse than the other type of externalization, is not the result of an agreement, is a de facto move, and is looking the other way to what happens to these people. And we don't know, by the way, to what happened to most of these people, because of those that are stopped at sea and returned to Libya, about 60% disappear between disembarkation point and detention center. And nobody knows where they are and what happened to them. So if that is not a violation and a matter of concern, I don't know what it is. Of course, the externalization presents also a series of challenges from a legal point of view. I come to Italy to request asylum, and I am supposed to be processed under a system that, from a jurisprudence and from a jurisdiction point of view, has nothing to do with Italy. So it's a surrendering of my responsibility as EU government, Italian or otherwise, to my responsibility to ensure due process in an asylum processing. One quick word, because I don't know how much time I have, and I don't know how much I have spoken, but one quick word on complementary pathways. Of course, I think is a positive aspect. The problem that I see is that most of the time, complementary pathways, the one that actually have some good result, are the initiative, I would say private initiative, private in the sense of Sant'Egidio community that creates a humanitarian corridor for some people to come from Libya to Italy, NGO or other representative of civil society that creates something similar, either a humanitarian corridor or other mechanism in order to assist people. but is never a proactive policy either of individual EU member states or of the EU specifically. And this to me is abdicating to the responsibility of the EU as a community of states and individual member states. The same that happens with search and rescue in the Mediterranean, where the EU and member states have abdicated to that responsibility since many, many years, attacked the NGO that carried them out, but yet without the NGO carrying out search and rescue activity in the Mediterranean, the number of deaths would be much higher, and it's already very high. So yes to complementary pathway if it is a proactive policy by either the EU as a community or individual member states, and not just clapping our hands because some NGO puts together some response that allows government to justify themselves for everything else that they do, saying, well, you see, yeah, we send back people to Libya, but then we have humanitarian corridor. Not really us, but still, it's sort of us. And so I find it more of a smoke screen than anything else. Now I shut up and thank you very much.
Thank you. Thank you, Eugenio, for your presentation. I think you raised very important questions to also follow in the panel, particularly when it comes to international obligations. This has been also subject of conversation during this week. The question of circumventing the law or reducing exposure to the law, bending the law when certain actors go abroad in this area. You mentioned you went into the notion of solidarity as a one way you described, and the use of funds and what we've learned from that. That made me think of the situation with Morocco and Turkey, how vulnerable this has made the EU, when using this kind of model of financial, let's say, incentives. And then the question of accountability, which is linked to responsibility that you mentioned, with these complex, extremely complex indirect ways of contributing to supporting Libyan Coast Guard actors. So thank you very much for your presentation. I'm sure we will come back to some of those points later. Now, let's move now to Tamás' presentation. Tamás, you have the floor.
Thanks a lot, Mr. Chair, Sergio. I prepared a very short, brief PPT. It's rather just a skeleton of what I will talk about. I hope it will appear on the screen. Yes, essentially, it's like 2 slides. So, good afternoon, everyone. First off, it's my utmost privilege to be here with you in the frame of this training school and then this policy webinar. The last time I was here in Fiesole in this very building was 12 years ago in the 2010 edition of the Academy of European Law of the EUI, and that was on migration law, by the way. I very much enjoyed that, and this noble man sitting on my right was one of the distinguished lecturers that I also vividly remember. And the whole thing, so I mean, when I returned, I just recognized the building. I knew where to go, and the Genius Loci is clearly here. I just feel it. So it's my utmost privilege and honor to be back again now in this setting. So as you can see on the screen, yes, it's both ends of the room. My focus will be both a quite legalistic one and focusing on one slice of this whole cake called externalization, as was mentioned by the previous speaker here and there. This is issues of responsibility for externalized border control activities, more specifically EU member states' responsibility under international law for breaching fundamental rights of migrants, asylum seekers, people on the move, when cooperating with third countries on migration. It seems to be quite a technical, specific, small slice, but it has its density and richness. Yeah, I've almost forgotten one thing before entering into the heart of the matter. I'm not speaking now on behalf of the EU Fundamental Rights Agency, but in my academic / intellectual capacity. I'm also a visiting lecturer at the Corvinus University of Budapest, which is my previous employer, but I still keep some times with the university, but I teach international migration law. So Frau hat off, other hat on, and please, this disclaimer applies. So this is the menu. I would like to talk about the international legal regime of possibly holding EU member states responsible for such violations of externalized border control activities with third countries under the general rules of state responsibility under international law as codified in the article on the responsibility of states for international wrongful acts. RCWA for short. International lawyers usually use this abbreviation. And we will see that in some scenarios, there are quite some gray zones of law where it's unclear how to apply these rules on state responsibility. And again, the focus is on the member states. I will not develop on the EU as an international legal person, as an independent entity's responsibility or its agencies. So Frontex, I'm not going to cover, neither from the international law perspective nor from a lex specialis EU law perspective. You know, there are some cases against Frontex under Article 340, so action for damages, Article 265, action for failure to act in the TFEU, but these are set aside only on member states. This is my focus. And I selected three main scenarios. The first, when I examine these issues, the first is when activities carried out, member states carry out activities in or for the benefit of third countries, like patrolling by member state vessels in the territorial sea of a third country, see the cooperation of Spain with North African countries, or various capacity building activities, training, funding, technical assistance, you name it. The second scenario is when member states carry out activities on board of third country vessels, no matter where these third country vessels from Morocco, Mauritania sail, but there are EU officials, EU member state officials on board as well. And the third scenario is when member states border guards identify people moving towards the green or the blue border, and they suspect that these people intend to cross the EU external border irregularly. Hence, EU national authorities share information and request assistance from the neighboring third countries to intercept these people before crossing the border. Let's start with the first scenario. I mean, here there are different settings and concrete examples, like the patrolling of a member state vessel in a third country territorial sea. I will set aside this, although it has also some legal issues, but the trickiest setup is providing training, supplying equipment, and other forms of capacity building by member states to the third country concerned. And the question is whether it can trigger state responsibility or not. Some scholars coin it as a form of contactless control, hence there's room for state responsibility. And there's a provision in the articles on state responsibility, namely Article 16 on aiding or assisting another state, which is the hook, which is the legal basis with which one can argue in this direction. Still, this Article 16 of the article on state responsibility is the most controversial form of international responsibility. Nevertheless, the International Law Commission, which initially prepared these articles, acknowledged that material aid to a state that uses the aid to commit human rights violations is one example of providing aid or assistance. But there are a number of other conditions so that we can apply it safely. So here the concept is that the responsibility of the EU member state for aiding and assisting is not triggered by its own unlawful conduct. Training, giving money, giving equipment per se in itself is not unlawful, but responsibility arises in connection with an internationally wrongful act committed by another state, like on the other side of the Mediterranean Sea. And if we take it to the extreme, and very expensive interpretation of Article 16 of the RCVA on aiding and assisting could have a chilling effect on international cooperation. So it's not the aim here. There must be a sort of a connection between aid or assistance and the commission of the internationally wrongful act, and this connection must not be too remote. In addition, this very Article 16 sets out 3 requirements to be fulfilled. So there's a quite high threshold which applies. The first is that the relevant state organ providing aid or assistance must have knowledge of the circumstances making the conduct of the assisted state internationally wrongful. One EU member state must know what Libya will do, for instance. Second, aid or assistance must be provided to facilitate the conduct, which must indeed result in a wrongful act. And third, the conduct must be Malta Declaration, preventing departures is there. And if equipment by member states is provided and information is shared specifically for this purpose, intent is then established. That was also the conceptual line proposed by the European Court of Human Rights in another case concerning CIA renditions in Poland, but the legal argumentation can apply. Second, looking at the precondition of the knowledge of the circumstances which makes the conduct unlawful, this is equally met when member states cooperate with third countries like North African countries or Turkey, since there's an ocean of reliable sources on the serious human rights violations and the very dire or even unbearable conditions in these countries. So there are some legal avenues to argue that aiding or assisting as a possible derivative form of responsibility applies in such a case. Second scenario, member states' activities carried out on board of third country vessels. Here, being conscious of the time, I will speed up. I will not dwell upon that too much in detail. Just to highlight that the essential issue is it revolves around the question whether or not member states' role played, or officials' role played, qualifies as exercising effective control, what the member state officials on the deck are allowed to do. And if it's not exercising effective control over the people picked up from the sea, rescued, still the right responsibility, as I just explained under Article 16, can apply if the above mentioned quite high requirements are met. Then let's move to the third scenario. So this is when member states share information with neighboring third countries to ask them to intercept people. Here again, the crux of the matter is whether the member state located at the external border exercises effective control when it shares information with and requests assistance from the neighboring third country, or whether effective control requires physical action. One way of reasoning is to say that these people are prevented from reaching the external border through the actions of the third country, of the neighboring country, and effective control is exercised only by the third country and not the EU member state officials. So that's one way. Nevertheless, such action clearly incarnates a form of aid or assistance to the commission of an international wrongful act, like obstructing the right to leave, or if ill treatment is inflicted upon these people. Then the other way of arguing is to say that member states do indirectly exercise effective control when they activate the action by the authorities of the third country through the information exchange. Since without information, the third country authorities couldn't set their, let's say, action into motion. So that was really conditio sine qua non. One article in the Frontex 2.0 regulation appears to support this view, as it prohibits an information exchange with third countries if the information could lead to the identification of the persons in need of international protection or those who are at serious risk of fundamental rights violations. So if there's effective control, we conclude like this, then the direct responsibility of member states is incurred in application of Article 4 of the articles on state responsibility. Now, just to conclude, the foregoing, or what I've said so far, shows, I believe, that EU member states are not in a legal accountability vacuum when acting beyond their borders in cooperation with third partners. So there are legal avenues. Nevertheless, a number of areas call for more legal clarity, and some gray areas remain, especially when the involvement comes rather from the background without a direct or simultaneous engagement in the commission of the unlawful act. But the RCV rules on aiding and assisting do have enormous potential to close the accountability gaps that the new generation of non-entrée practices seek to exploit. So far, we don't have any case law on that. No international, no regional, so neither from Strasbourg nor from Luxembourg. Then it remains debated whether the conduct of an EU member state entails international responsibility in these situations, under the umbrella of international cooperation, but in many cases with the ultimate aim of preventing people from heading towards the EU. I'll stop here. Thanks for your kind attention.
Thank you, Tamás, for your presentation. There were some moments where apparently some of the colleagues who are joining us via Zoom were losing the sound. Something we could do, in addition to your PowerPoint, is to share perhaps a paper that you may have written about it, so that everybody will have access to it as well, together with other readings.
Yes, I mean, I published the blog entry on that. Like, it's a short, less than 3,000 words piece. So
yeah, so let's do that
as a background.
I mean, they listened, but there was a moment they missed. This was just one moment, so just to be sure. Thank you so much for taking us through this framework that, as you said, is not there is not a legal accountability vacuum. There are ways, but of course they're extremely complex. By design, there are a number of gray areas but still there are ways to depict situations of direct responsibility by member states. The question also is then, what about indirect responsibility of European institutions or European Union actors? Next presentation is by Inma. Inma has been very much involved actually on the matter of Libya in Brussels. And really informing constantly. We talk about knowledge of what is happening in the country. And as mentioned before, we could also distribute this paper to the participants. MSF recently published a paper on complementary pathways that hopefully you also will take us through briefly, you know, what were the main messages there. Inma, you have the floor. Okay.
So thank you very much for inviting us. So I work for Médecins Sans Frontières, so I will bring this medical humanitarian perspective to a subject that is very political and legal, if you want. So yes, I wanted to use the Libya example because I am going to take Eugenio initial words that is the best example that to reflect the obsession of the EU to stop and the return at any price, despite the evidence and despite everything that, well, I will go through some of these points. No, so what I wanted to highlight is how the not just the political narrative, but the day-to-day narrative of the EU leaders and the EU just normal officials everywhere has bought arguments that are used to justify what is just unjustifiable. No, so in 2017, Libya. So I will concentrate on Libya. The arguments were built around the fact that this externalization, meaning stopping proactive search and rescue, the official one of the EU, and then find the means to end also the one of the NGOs that came just to cover the gap, and at the same time that training or equipping and I will go more and encouraging and preparing the Libyan Coast Guard to declare an extended SAR zone, which is the one that afterwards they will use to say, no, it's not our responsibility, but I will go more in detail to this. So that's the externalization in Libya. So and then to create the system of interception and return and say, so that this is a life-saving. So the official, not the official, everywhere this was a life-saving activity. This will end the trafficking. There will be no more trafficking that we will cut, and then this will help to dismantle the smuggling networks. And then this will also convince the European member states to expand safe and legal channels. And it was not complementary pathways, it's safe and legal channels. So this was the thing. And of course, all this was rights respectful, perfectly rights respectful. Well, the reality shows a completely different picture, as you know. I will go through some of them, but it's not just, so MSF, we have provided and issued a lot of reports of the testimonies that we collect of our work in search and rescue, and also our work in the detention centers in Libya and outside the detention centers as well. But it's not just MSF. I mean, there's the reports from OHCHR, the Council of Europe repeated reports year after year, almost the Human Rights Commissioner with recommendations. There is the FRA, the criminalization, the reports that they also issue every year or every 6 months on criminalization of search and rescue. So there is plenty of evidence. But I will say, just on the basis of the assumptions. So life-saving. Well, life-saving means that they have created an endless circuit of departure, attempted departure, interception, return to detention center. This means that they pay more they do more attempts. So now in the latest testimonies, we have up to 6-7 times that they try to cross. Then they pay more because they have to pay not only the several attempts, but also every time they are released from the detention centers, where we have testimonies of people that have been detained up to 12 times. So they have to pay because they have to pay when they go out. So when they go out, then they pay the smugglers and so on. So that's the thing. There is the mortality, the numbers of, well, these are estimations that are made by IOM, mostly by IOM. So we have this year is a 1,200 estimation, I think, of missing and dead. Yes. And since 2017, which was where these policies were made, is 17,000, I think I have. So, and also the ratio between the ones that are missing or dead and the ones that depart is higher than before, when there were higher numbers, but the ratio was lower. So that's so mortality is there. There's the smuggling is, of course, perfectly healthy and wealthy inside Libya. There is also evidence that the Libyan Coast Guard are part of the smugglers. So, and we have testimonies that we have shared with the EU, but there are also the evidence collected by others, Amnesty, and the internal reports that have been leaked of the EU. There is the mortality. So then we have also, of course, one very important point is when the EU was justifying in the documents that there is the support to the Libyan Coast Guard, they had a document that is called Action Fees, which is a programming document. So it's the document that this is made by the European Commission. There is no Italy. This is the European Commission that drafted the objectives of the support to the Libyan Coast Guard, among other objectives of the funding in Libya. So here they were saying, yes, we will support the Libyan Coast Guard to the equipment, but then to expand, to be able to expand the SAR zone, to declare it, and to be able to operate in this SAR zone, and to be able to do the coordination of the operations, because this was in line with the objective of eliminating the coordination of the Italians and the Maltese. Okay, so there was this was phase 1 of the project, and then there was a phase 2, and there were indicators there that to pass from the first phase to the second phase. And in this, the indicators, for example, were that the Libyan Coast Guard was going to be willing and able to operate in that SAR zone. For example, that the Libyan Coast Guard was going to behave according with human rights, and that the situation inside Libya was going to improve. So all these indicators were there. Meanwhile, we were providing reports of what was happening, but not us, I mean, MSF, OHR, I mean, all the rest, the Council of Europe, and the second phase was approved. So maybe there, the experts can find some links. So that's one thing. And then the other main argument, so the system, the entire externalization system with Libya is based on interception and return. And then to justify the unjustifiable, and I use the arguments that you were using, is to say, but no worries, this is fine, because then there is the UN and the NGOs inside that are going to ensure assistance and protection with our money, the EU money. So no, obviously this is assistance and protection in Libya is almost an impossible task, extremely difficult for the UN, for us, for everyone that is trying to work there. And as Eugenio was saying, so it was never, and it was after year, we were proving this, that it was not possible to control what happened after disembarkation. So there is no, it's not the maximum that we have managed to do, the UN. Now we are also in some disembarkation points, is to do some medical checks and to try to convince every time the most severe cases that they are referred to a hospital. So that's the maximum we managed to do at disembarkation points. So again, I like to insist on the fact that year after year, with all this evidence, the EU was still repeating and still signing new grants and still passing from one phase 1, phase 2, and so on. So this is for the, so then I go directly to the complementary pathways, because I think I am speaking too much. On complementary pathways, we like to talk more about humanitarian corridors, but first I have to say, no, that's not the solution. Of course not. So the solution will be that there are safe and legal channels open as a base, and the problem is that these complementary pathways, they are associated to the containment policy. So in that sense, it's not right. However, in pragmatic terms and in pure humanitarian perspective, MSF is trying to collaborate to try to identify as part of the mechanisms to identify solutions. So at least for the most vulnerable. And what is very important to insist on is that today, because of the lack of protection space, because of the difficulties inside Libya, so the evacuation mechanisms are struggling, that managed by UNHCR and IOM, and in particular the one of UNHCR, because they have even less access, because less acceptance of their protection mandate, if you want, or less flexibility, and that the numbers are really small. So we are trying to see if this the expansion of humanitarian corridors could be a possibility, and then this will be humanitarian corridors directly out of Libya to Europe or other third safe country. So, for example, there have been some cases that have gone to Canada with the sponsorship, the refugee sponsorship program. So then, yes, there is the humanitarian corridor from Libya to Italy. That is San Egidio. MSF is referring some cases there also. And we are trying to do more. We are discussing with some other European countries to see if they also agree to do humanitarian corridors. San Egidio is doing that directly. We are also collaborating with them in some of them. We are trying to explore and do a bit more with humanitarian visas, but it's still very tiny. Switzerland has accepted some. Then there is the family reunification, but it's also very difficult. This goes through all the processes of UNHCR, and UNHCR is struggling and so on. It's still very telling that the focus of protection in Libya is still with the, I think it's the 9 nationalities, when everyone in those centers is extremely vulnerable, have been subject to violence, torture, everything. I mean, and I don't want to go on the details of what we witness on the ground because it's really, really terrible. But yeah, maybe I leave it like this. So yes, humanitarian corridors for us is important, but it's a pure humanitarian tool for mitigating the situation. We don't want to call it solution, and especially we don't want to call it solution if it is associated to containment policies.
Thank you, Inma. Thank you for your presentation and also the details that you've provided in terms of knowledge. You know, the knowledge that, you know, organizations like MSF have provided constantly to European institutions about the impact of these policies. And a very specific example of the role of the European Commission when accepting the Action Fish 2, despite all the evidence to continue supporting financially what is going on there, is a very clear example of, you know, who is responsible. We know that DG NEAR has been very keen on continuing this kind of cooperation, and yet what is still unresolved is question of who is responsible then. When there's clear evidence of you know, international wrongful acts in the country. I also believe, and I will also wanted to make it in public, because I believe, you know, after so many years in Brussels, I see the role that actors like MSF play such a crucial role in informing policies and really providing really first-hand knowledge on, as you mentioned, actually people suffering and policymakers, you know, listening to that, and yet some decisions still being taken or not taken to change the course of action. You also mentioned about the legal pathways being captured by containment. This is also very interesting a component for the ASILE project, because we actually look at those two, mobility and containment. How do they actually work together? What is the interplay between mobility and containment? And what you mentioned, these humanitarian corridors. In that situation, you know, how do we need to read them in terms of what are the real options that are given to people, meaningful options to people to move out of Libya. So thank you so much for your presentation. The next presentation is by Cecilia. Cecilia, you have the floor, please.
Okay. Thank you very much. And thanks for the invitation to participate, even if just online. Can you hear me?
Perfectly, yes.
Perfect. Okay, good. And for allow me to share some of the perspectives of DRC's work. As Sergio has mentioned, DRC is happy to be a partner of the ASILE project. And I'm sorry that I wasn't able to be with you these days. I had a look at the agenda and it looked very interesting. So I hope you've had a good couple of days. As we've heard already, containment and externalization measures and policies are in essence designed to transfer and escape responsibility. And therefore it raises multiple questions on accountability for the rights violations that may follow. And I want to thank the previous panelists for some very interesting legal perspectives on both responsibility and accountability, as well as the link between those two. And also for the latest account now on the very serious consequences of EU's practices in Libya. I'll try to follow the latest presentation by sharing two practical examples on containment and externalization policies and practices that are either driven or at least pushed by the EU. We're focusing on the derived rights violations and protection implications for people. And then I'll try to share a few reflections on alternative policy options, although that's obviously a very broad area. But firstly, drawing on recent works of colleagues at the Mixed Migration Center, which is part of DRC, The first example that I wanted to mention is perhaps a bit more of an indirect consequences of some of the policy responses that followed the IEA takeover in Afghanistan in August last year, and the derived consequences that those containment policies aimed at controlling and restricting mobility can have on people in need of protection when they become unable to leave a situation that they need to leave. While important and substantial efforts to evacuate those at immediate risk, we all saw that in TV, were made when Kabul fell last year, the crisis and displacement situation was seen by the EU leaders predominantly through security lenses. And the response was characterized by a preoccupation or an obsession, as we've heard, of containing refugee populations in the region, seeking to avoid any onward movements towards Europe. The situation in Afghanistan and the related displacement was and continues to be a severe protection crisis, and it should, of course, be addressed as such. We probably all know that Afghans face rights violations on a significant scale and perpetrated by multiple parties this year. Restrictions from the de facto authorities increasingly limit girls' ability to access education, as well as women's ability to earn income and access services. While we know that previous members of the army and government and former government are at risk of retaliation. So these concerning situations are compounded by the imposed restrictions of women to serve as human rights defenders and judges under the new regime. And we know that girls may be forced into marriage by families needing income to survive. So 1 year after the IEA takeover, many Afghans who were not able to board the evacuation flights last August, including Afghans at risk of persecutions, remain now without options of reaching safety. And this is due to a combination of the intermittent closure of land borders, as well as the dangerous and expensive overland journey, but also the securitized responses from neighboring countries, as well as countries further along. And then, of course, the very limited regular migration pathways that are available to Afghans. According to the data that the Mixed Migration Center collected, Afghans can only obtain visas in a few neighboring countries, and the process is very difficult and expensive, and therefore not an opportunity for most. And we've already heard about human smuggling and how this comes into play, and obviously when it's so difficult to leave covert migration routes, and the use of smuggling services will be the only option for many seeking protection, and that will push up prices for smuggling services as a consequence of increased demand, making it even more difficult to access. And then the second example that I wanted to mention that we already talked about today, other panelists have talked about today, is what happens when when Afghans are able to actually manage to leave Afghanistan, but then on the journey are exposed to multiple risks. There are risks of arbitrary detentions, possible refoulement back to Afghanistan, and at EU's external borders, Afghans as well as, of course, many others experience illegal pushbacks. We've heard about the practice of trying to keep out refugees and migrants out of the EU territory with the use of violence and pushbacks, and thereby denying people who want to apply for asylum that possibility. And DRC, as part of the Protecting Rights at Border initiative, we and partner organizations have since 2021 been registering pushbacks and other human rights violations at selected EU borders. And the findings of the report show that pushbacks at EU borders are not to be considered isolated cases. Rather, there is a systematic use of pushbacks, and it becomes a de facto tool for border management. Pushbacks also take place as collective expulsions across multiple borders following cooperations between EU member states, so-called chain pushbacks, and they sometimes even include the ad hoc use of readmission agreements at certain borders, which means that some asylum seekers can be pushed between different member states and then out of the EU. In 2021, the initiative registered 12,406 persons who were being pushed back. And during the first 3 months of this year, 1,911 persons were registered to be pushed back. More than half of these people came from Afghanistan, and they included families with elderly, with women, and with children. With the conflict in Ukraine, and we've also touched a little bit upon that today, there have also been third country nationals from Ukraine who's been registered as being pushed back, and therefore being hindered access to applying for asylum in the EU. In this initiative, we met an Afghan mother and her 2 children who had fled Ukraine, but were being pushed back from Croatia to Bosnia on the 18th of March, so a little under a month after the war in Ukraine started. The family had immediately asked for protection when apprehended by the authorities, but police had informed them that there was no place in the camp, drew them back to the border and told them to leave and go to Bosnia-Herzegovina. Additional to the pushbacks and prevention from the right to seek asylum in the EU, people have also reported being subject to different types of violence and other human rights violations, such as being abandoned in remote areas, including forests, physical and verbal abuse and assaults, as well as theft, extortion, and destruction of property. So if I were to point to just a couple of policy options here, although very different, these 2 examples do illustrate the serious negative consequences that European asylum and migration policies can have on the life of people who are seeking protection, and any policies must of course try to counter these consequences. A few comments on containment. It's obviously that the EU should avoid policies of containment because they contribute to making access to protection more difficult. Containment policies that aim to control and restrict mobility leads to criminalization of border crossing. And as we've heard today already, they nurture human smuggling and make access to crossing borders contingent about people having resources and means, and push people into increasingly more dangerous routes in the search of protection, rather than actually deterring them from trying to reach Europe. Unintended protection implications of EU asylum and migration policies should be explored and documented to ensure that future EU policy responses are based on evidence. Here, obviously, academia has a role, but I also think the importance of engaging with people who live the consequences of the policies is key, and probably, sadly, to a large degree, overlooked here. On responsibility, I think, even though it's been said so many times, NGOs, others keep mentioning this whenever we have the opportunity, but it's important to stress that refugee protection is a global responsibility. And the effects of EU policies, either direct or indirect and long-term, can be very negative on the treatment of refugees worldwide. So to ensure that refugees have access to protection and to show the necessary solidarity with the largest refugee hosting countries, EU member states must make it easier to reach the EU legally and, importantly, safely. And I think it was a very interesting discussion now on complementary pathways and the role of that. So maybe just leave it here by saying that increasing resettlement numbers is obviously one part of that, and expanding, for example, possibilities to get family unification, making it less difficult, and administrative burdens, or lowering them as well is an important point here. And I think the EU response to the refugees from Ukraine has showed that there can be political will to join the help of refugees when there is also here a safer access of mobility channels. We can see that it can be done. Finally, on accountability, I think it's very obvious with all the documentation that there is on what's going on at the borders of the EU that good faith is not enough to ensure that border management is human rights compliant. So all member states must take responsibility for ending pushbacks and holding each other to account for violations. And to promote compliance with fundamental rights, member states must establish independent and effective border monitoring that ensures accountability during all border surveillance activities. And here, national human rights institutes and NGOs can be useful to ensure the possibility to complain for people who experience pushbacks and other violations. And I think it's important to remember that refugee and asylum seekers are obviously in a vulnerable situation when seeking protection. And when they're subject to these border measures and other externalization measures, it will be very difficult for them to access the available legal remedies, if there are any, which there most obviously will be. But it will be difficult for them to access them. And that means that it's very important, that it's absolutely key to have a proper system in place of effective and independent monitoring of whichever policy that's put in place, and that there is a clear pathways of challenging decisions or wrongful actions of the different actors involved. Thank you very much.
Thank you. Thank you, Cecilia. After listening to the four of you, I just felt this, this increasing realization. There is an increasing realization that whatever is happening is not only having huge impact on people, but also the credibility of the European Union and governments in this area. We see more and more stories in the press, in the media, reaching out the public as well. Many times these conversations are not held with people. People do not know about EU cooperation with Libya. People do not know about EU cooperation on Turkey. This is always closed door in Brussels. And there is this naturally emerging realization and collective realization that we need to speak about this in a very clear way. And many of you have said also stop containment in the sense of as a policy in itself, in terms of public policy choice of containment, with everything that we know it has carried so far. So few of you have talked about the obsession that keeps on coming back, this idea of obsession. And I'm sure we will explore that in the Q&A. Also in relation to the ASILE project, this politics of responsibility, evasion, and shifting is very interesting. But, responsibility, evasion, and shifting, because we do have EU rules. We do have a Schengen Borders Code. We have EU Returns Directive. We have, EU Asylum directives. We have a whole series of laws which actually require member states to behave in a very specific way. And yet, many times we see this disconnect between what the rules say and the actual practice of this evasion, shifting, bending, or reforming the rules, reforming the rules. We've seen recently these new legislative initiatives on instrumentalization or reforming Schengen, precisely to legalize ad hoc actions that are currently unlawful in light of the Schengen rules when it comes to reintroducing internal border controls or allowing people to have access to asylum. So this is something that is ongoing, and it's not just a question of noticing it, it's really to have a conversation, a proper conversation of the impact of these reforms, not only in Brussels, closed doors, but with people who are actually having a voice, those who are affected. You mentioned also those who are affected, but also, the public at large. Let's have a conversation about this. So what else? Yes, Tamás mentioned and actually kindly shared with me Fundamental Rights Agency practical guidance on establishing national independent mechanism to monitor fundamental rights compliance at EU external borders, that Cecilia also mentioned, the great work of the DRC in the project Protecting Rights at Borders. She also called for this independent monitoring mechanism. This is something that has been there. The European Commission actually suggested in the EU Pact, and yet this has opened up a number of questions on how to ensure independence, effectiveness of this monitoring. But the FRA is really providing crucial guidance on this and highlighting what exists in EU law. There is a table on EU law instruments, and there's a whole series of EU law existing instruments, actually a whole series of them that are very often not applied simply, or not accessible in practice, So thank you so much. Now there's few people who've already contributed with questions in YouTube, but first I would like to open the floor here for questions. And please be very brief, introduce yourself. I will gather for you, and then we come back to the panel. Please.
Hello, thank you very much for the wonderful panel debate. My name is Tala. I'm a visiting fellow at CEPS and also a PhD researcher at Leiden Law School. So my question will be for Tamás. Back in March 2022, I had the pleasure to read your blog on EU migration law blog, and now it's a great pleasure to see you presenting it in person for me. My question will be, 2 days ago, I made a presentation on the international responsibility of the EU this time for Frontex surveillance activities in the Libya context. So in this sense, I was wondering your thoughts, because we also know the recent OHCHR report for Libya and the reference of the Commission of Crimes Against Humanity, as well as the possible involvement of third countries, but no mention whatsoever to any international organization such as the EU. So I was wondering your thoughts on the following premise. The international responsibility of the EU for Frontex border surveillance activities in the Libya context is a theoretical possibility. So I was wondering your thoughts on it.
Thank you. Any other questions in the public? Andrew.
So I'm Andrew Geddes, I'm the director of the Migration Policy Centre here at EUI. It was a question, I think, it came from something Cecilia said, and I think perhaps also for Inma and Eugenio. It's about, well, what we've been doing the last couple of days is thinking about evidence, research, evidence, and developing argument. And your presentations are focused on, really on almost like a collective obsession, immunity to evidence. So I was wondering if in your experience, whether you're finding ways in which evidence and research can make a difference, can have effects on policy and practice. So really it's kind of what works and what kind of, what can we as researchers learn about how we could maybe try and make a difference through research that we're doing.
Thank you, Andrew. Sanjeev.
I actually had a question for Eugenio. So you were talking about the shrinking of the protection space over the past 20, 30 years, and you were talking about the existence of this model of closure across the world, right? So as you know, Bangladesh's historic sort of relationship with non-refoulement, it hasn't been particularly steady. It's been an uneasy relationship. But since 2017, for instance, it has upheld the principle of non-refoulement with regards to Rohingya refugees. And, to the best of my knowledge, the Bangladesh border officially remains closed, but de facto, it remained open in 2017 and 18, which basically allowed more than 1 million Rohingya refugees to come in and remain. So my question is, how do you think Bangladesh as a country that hasn't really ratified the Refugee Convention, for instance, either fits or doesn't fit into this model of closure that you described? Thanks.
I am maybe not the best place to say what happens with evidence. I can tell you to start with that is for us in our humanitarian perspective is extremely frustrating because of course we think short term, and if evidence has an impact, it will be long term. So it will not help the people that we are seeing now in the detention centers for sure, or at least it has not helped them until now, apart from some small, tiny solutions that we find for individuals. So maybe, for example, just I mean, I don't know, some victims of torture that we have managed to evacuate, but it may take 6 months just to negotiate all over to just for a few people where there is clear evidence. This was the case of a group of people that were escaping from clandestine detention, and they were shot at, and then they came to a medical facility of MSF, and we collected all the medical. So with all the medical data, all the things, it took us months and months. But this is not even responding to your question. So the evidence, so we do these reports, we make them public on purpose so that they are used. We share bilaterally, but officially, some information with the EU institutions that we hope one day is useful for something, but it's extremely frustrating. We tend to think that this useless, but we hope one day it will not be. I don't know if I am really responding, but in any case, we don't have a choice. We have to document. We cannot continue doing, part of our humanitarian work is documenting. Because when we are working, working in Libya, for example, in detention centers, is a serious dilemma, because it's not the medical care that they need, or some of them, they also need the urgent medical care, and we do medical referrals, but it's not that. I mean, we need to try to contribute to find solutions for that problem. So otherwise it would be better not to work, because we could say that we are contributing to the problem because we are alleviating. So it's a moral dilemma in humanitarian terms. So the documenting is very important for us in these files, and we hope one day it will solve. And then for the other questions, I don't really have, I think it's better for the other, on the legal and so.
But I've also seen, if I may, also the documenting, you guys being in the European Parliament, in Libe Committee, and informing conversation between MEPs and European Commission.
Yeah, we do all the time, and we send official reports to the. So before, for example, in some of these things, I would send them mails, mails to officials. Now I send formal letters, because when I send the formal letter, it is on the record. So if any of you, for example, want to ask about MSF correspondence, you can ask, and then you will have that, because it's. So this is something that we are doing, and also because they need to reply. But lately they haven't even replied to formal reports and formal correspondence. So yeah.
Thank you, Inma.
Yeah.
Eugenio.
Yeah.
Thanks. I don't know if I have an answer to your question, Andrew, because I think on many situations, it's evidence is there and has been for a long time. Some other situation maybe less, but if we take the example of Libya, I don't think there is any way that anybody in Brussels or among EU member states can claim that they don't quite know what's going on. So the possibility of evidence influencing policy making seems relatively small as far as the policymakers are concerned. Then maybe there is an aspect that Sergio was mentioning before of having a more in-depth, precise public discourse with the community at large, not just with the policymakers. And that's maybe a way of allowing evidence to make a difference, because right now, if we look at many EU policy in migration, in the migration sphere, they seems to me they are made despite the evidence. Without going to Libya, even when we talk about return and return, voluntary return is one of the largest programs that my organization carries out. So I have nothing against voluntary return per se, but the fact that return is the only answer that the EU has, regardless of who comes, whether there are protection concerns, even if they're not refugee or asylum seeker, whether there are concerns about the country of origin where we return them to, et cetera, et cetera. The fact that this, again, obsession on return has not made a dent on the irregular migration or the attempt of crossing, et cetera, et cetera. More evidence than that, and still it continues. So I think at the policy maker level, I would have some doubts, even, if you say that funding the Coast Guard to stop people and return them to Libya is a life-saving measure. I mean, it's difficult to think that on the other side you have somebody willing enough to actually entertain evidence. That's just a measure to ensure that they die somewhere else, not on EU territory. So we are fine. On Bangladesh and your question on Bangladesh, I think with all the other aspects that are problematic in terms of the handling of the Rohingya situation, by the way, that better than me, so I won't even try to get into that. But in terms of the border being open or not open, and therefore allowing people to cross, I think Bangladesh, as few countries around the world, most of them coming from the south of the world, it's a good example. And I think that should tell a lot to EU member states, EU citizen, we want to be, as EU, the promoter of democracy and human rights, etc., etc. But there are many other countries that don't have the same public display of democracy and human rights that actually apply a certain principle much more and much better than the EU. So in that sense, I think Bangladesh is a positive example. Then you have more than 1 million people in Cox's Bazar. So you have a series of other issues. You have the island, which I can remember the name, where they want to transfer some people, etc., etc. The fact remains that for the last 4.5 years, over 1 million people have found some sort of safer haven in Bangladesh than where they were coming from. And I think that says a lot of positive things on the country specifically.
I agree with
Good.
Once.
Thank you. Tamás, there were a couple of questions. I would like to invite you also to comment on the evidence, the remark on evidence, and also one of the participants in YouTube posted a similar question than the one of the Tala about crimes against humanity in Libya and the EU's responsibility before the International Criminal Court.
The EU's responsibility before the International Criminal Court.
Yeah, if you could offer your thoughts on that.
Thanks very much for the questions, very insightful and interesting ones. I mean, I start with this more legalistic, technical one. I must admit, I'm amazed by the depth of the more legalistic, the better for me. So I would say in brief that yes, EU's international responsibility in principle for acts committed, which are not in line with international law obligations incumbent upon the EU, for instance, with regard to the cooperation with Libya, can be engaged. So in short, the articles on the responsibility of international organizations, which is the general framework under international law governing these issues of responsibility of international organizations, this applies to the EU. One might say, hello, we have a lex specialis clause in the REO, which is called for short, Article 64. But it's question of interpretation whether lex specialis, given the way it's framed in the REO, would apply to the rules, internal rules of the EU, where one might conclude that yes, the internal legal toolbox of the EU legal order sets out enough self-standing remedies or actions or procedures which can hold the EU accountable for acts committed in contravention with international legal obligations. So it's quite complicated. But let's say the lex specialis rule applies, and we should look into the EU legal order, what is offered to make the EU and its emanation, its organs, bodies, offices, agencies responsible under EU law. And if we just go through this path of EU law, I can identify at least 3 legal avenues. The first is the action for damages under Article 340 of the TFEU, and the same is reflected in Article 41, Para 3 of the Charter of Fundamental Rights. So if anyone who has been subject to any damage or because of EU institutions and the other entities' action, that person can seek remedy before the EU courts. In this regard, of course, it's hard to find the right person. So there was someone who ended up in a Libyan detention center and was subject to really tough ill treatments, torture, whatever. That person, finds a lawyer with the power of attorney who can just initiate an action before the Luxembourg Court of Justice, before the EU Court of Justice, invoking this specific primary EU law provision to initiate the action. So there is a lot of ifs, and practically speaking, from the courtroom perspective, it's not easy to go along this path. But theoretically speaking, it's there. The second would be Article 265 TFEU, action for failure to act. In this regard, like an emanation of the EU, Frontex, as an EU agency, fails to act, didn't stop the operation or turn the blind eye, whatever, and that was the consequence of a human rights violation. then it can be again another avenue. But in case of individuals, we know that this action has a very, very important bottleneck: the limited locus standi of individuals. And now there's a pending case before the EU Court of Justice on that very matter. And the crux of the issue, I think, this is admissibility, whether the EU court in Luxembourg will say this action is admissible. So whether the Luxembourg judges will say the individuals concerned are individually and directly concerned by the lack of action of an EU entity here, Frontex. And this is walking on a tightrope. It's really, so far, the jurisprudence is quite, reserved. There's always room for revirement jurisprudentiel, just to change the case law. Maybe this will be, maybe not. We will see. And then the third legal avenue, it's Article 263, the action for annulment. If there's any kind of materialized act by an EU agency like Frontex, a decision, a piece of paper, whatever, that can be attacked, then this is an avenue. In this regard, when these kind of real acts happen out in the woods at land borders or at high seas, it's not the case when there's some formal act against which you can initiate a challenge. Sorry for being a bit technical, but I think it's important to talk about this, since the debates sometimes are overwhelmed by policy arguments. But what makes change? Maybe I'm biased, but law makes change. And everyone then talks about rulings, case law, and we just need to know how new case law can arrive at our table. So we have to sometimes roll up our sleeves and go into these legal intricacies. Otherwise, we are just running in circles. Then the next question about gathering evidence and the role of evidence, its possibility to influence policy making. Here, I would like to do some shameless self-promotion of my agency, although I'm not speaking on behalf of the Fundamental Rights Agency, but the raison d'etre of the Fundamental Rights Agency is to provide reliable evidence on the implementation of different fundamental rights across the EU, both for EU decision makers, for the EU institutions, co-legislators, as well in the policy making process when a new EU legislation is being drafted or negotiated, and also for member states when they are implementing their national measures or the EU measures, to make sure that the implementation is fully in compliance with the fundamental rights obligations of the member states. So we are conducting social legal research, and it's not just desk research and doing hopefully good legal analysis, but this is embedded in empirical evidence gathering via surveys, by different kind of even fieldwork missions, by a different kind of information sources, applying thorough sociological methodologies as well. So we believe that we produce something which is useful, and it's more than just we believe in a number of areas. And I would also say migration/asylum/borders. The evidence we produced is then taken into account by the Commission, for instance, or the Parliament throughout the trilogues when there's a negotiation or a legislative proposal. I could say from the Commission perspective, when we publish something on the criminalization of irregular migrants and the people engaging with them, that was significantly taken into account when the Commission prepared its previous action plan against migrant smuggling, and the list goes on. So of course, it's always a debate whether the glass is half full or half empty, but speaking from a bona fide, good faith perspective, I would say it's half full. And there are other examples as well. So now, for instance, in the context of the Ukraine war and in the Russian aggression of war in Ukraine, we are also collecting evidence on the implementation of the Temporary Protection Directive across a number of member states. And we feed into different information exchange and awareness raising and preparedness mechanisms coordinated by the European Commission. So cutting the long story short, we are producing evidence, and the evidence is taken up to I would say, a tangible, visible extent, both by EU institutions, namely the Commission and others as well, and also member state. There are some other examples for member state cooperation where we can see I would say one example. Just the Croatian Minister of the Interior asked FRA to send one of our documents. It's a guidance for border guards on how to uphold fundamental rights at external borders. This small pocket guidance, which has been translated to Croatian, 6,000 copies, so that the ministry in Croatia could distribute to each and every border guard wherever they work. And we did that. So now, at least in principle, every single border guard in Croatia, no matter where they work, has this pocket guidance in their pocket in Croatian. If they want to see how to proceed, they have it. So it's a very nice way of making a change. I'm not saying the picture is fully rosy, but as an optimist, I can see avenues and the real tangible impact of that work.
Thank you, Tamás. Cecilia, I know we've talked about this question of evidence a few times as well in previous ASILE meetings. Can you share your thoughts, please?
Yes, thank you. I think, I mean, I do share some of the frustration and maybe lack of believing in evidence or in the power of evidence to actually change some of these policies when we look at what has happened previously. I think so. Maybe I'll try to raise a few other points. I think there's one thing is around engaging in policies. Others is using that evidence in other forums. Strategic litigation, for example, in much of this evidence will be mentioned by courts around Europe, by the European courts as well, of course, but also in national courts. And we see some of our material mentioned there. And I know MSF material is often mentioned by courts around Europe. So that's obviously also a place where evidence becomes important. I think just the media attention on borders has had some effect. What effect, we don't know, but obviously I think it does, just because it's become very much on the top of everyone's mind. I think who works within this field, and it is also, I think the exposure in media has also forced the EU Ombudsman to act, and I think so that's obviously also an effect of proper evidence, or having that, and bring it forward, both in the policy sphere, where I think it's difficult, but I mean, I do think the European Parliament, for example, and the communications there, I do think that evidence still have some effect there, national level as well, and then to be aware that data translated into evidence is something that's used in many forums, not only at the highest EU policy level. That's one. There's a question specifically on the Dublin system, I think directed at me. Do you want me to take that as well, Sergio, now?
Yes, please.
Okay. I think it's an interesting question. I don't know if I have a very good answer, but it's about whether the Dublin system could be assessed through the externalization lens. Looking at sort of the damaging effects on the people. And I think for sure, I mean, this is a system that's based on safe third country, of the other countries being safe third countries. So similar to some extent to some of what was put in the EU-Turkey statement. I think what's a very clear lesson from many years of Dublin jurisprudence is that mutual trust is there. Obviously it's Dublin system is based on that, but the member states cannot just lean back and account and be sure that or have that mutual trust in terms of compliance with fundamental rights. I think that is a very clear, that's very clear, has come out from both European courts in relation to Dublin, and that's obviously even more so when we talk about outside of the EU. Then I think when we talk about the Dublin system, I just think an interesting parallel is one of the reasons that many will say that the Dublin system, and myself included, has not been successful in many ways, is that there has never been success in achieving a well-functioning responsibility sharing mechanism. And I think for externalization practices, I think this is relevant as well, that responsibility between the countries of the world, and not having some countries that evade all responsibility for themselves is so important in order to keep refugee protection sort of in the core of what we do within this field. So rather than evading one's responsibility, being part of a global refugee protection system is what should be on top of all of our minds within this field. So that is the parallel that I will make there. But obviously it is about transferring responsibility to another country that you deem safe. So for some externalization measures, especially the ones that a couple of countries, I'll try not to mention any names here, are trying or models that they're trying to materialize on externalizing outside of the EU.
Thank you, Cecilia. So the failures inside are informing externalization as a non-solution. The failures of not really having a proper, an efficient responsibility sharing system, finding solutions elsewhere, and these are not solutions; they are non-solutions in a way. But also the point of your evidence I found very interesting, linking up with how data, data collection by NGOs on impact of policies, how research and investigations find place in interinstitutional processes and accountability venues at EU level. And in terms of how that also, also as Tamás was saying, and I always remember one of the papers we wrote where we actually were raising question about the European Union's responsibility for crimes against humanity in Libya was expressly quoted in the EU Pact on Migration and Asylum as in a footnote. And I was very, happily, of course, very happy that our paper, our research is quoted, but it was quoted more referring to the lack of a search and rescue, EU search and rescue mechanism in the Mediterranean. But if you read the paper, we actually, together with my colleague, Roberto Cortinovis, we actually raise the question of EU's responsibility for international wrongful act. And this is directly quoted in the pact as well. Now, there are a couple of participants who raised their hands, and I have one question also written down. Who was first? You, sorry, Jens?
I just want to,
sorry, Tamás,
I just
please.
to
Sorry, I didn't see this. Please.
I'm sorry, I just realized that sadly I forgot to address one of the questions that we received via the chat. So the international criminal responsibility of the EU before the ICC. I mean, technically speaking, if I understood correctly, and that was the question, I can't see that happening procedurally speaking, since the EU is not party to the Rome Statute establishing the International Criminal Court. These are only member states. I mean, states can be parties to that. Of course, it's another question of when we can argue with this, that EU entities or officials under EU flag committed some wrongful act, which can be attributed under certain conditions, again in the REO rules to a member state. So it's like a upside down scenario, but technically it's possible. But if it's not the case, it's very, very tiny. Besides this very, very tiny avenue, I would say that the EU cannot really, as an entity, be successfully sued before the ICC for that reason. And I think the current, let's say, cases or situations referred to that don't single out the EU, but there are also references to member states officials who might have committed or contributed to the commission of those crimes set out in the Rome Statute. And one more thing, and this is also the general chapeau comment, when it comes to invoking responsibility under international law, either member states as sovereign entities or the EU as an international legal person or its agencies. The big question is before which forum, how to adjudicate claims, even if from the substantive law perspective, it's a clear-cut violation and you have all elements to say responsibility incurs. But where to go? For states, it can be easier, but again, who initiates against an EU member state? I don't see it happening. And before international organization, we know because of their immunities, they cannot be sued before national courts. There are no international courts before which international organizations, including EU agencies, could be held responsible. So it's very, very hard to make it happen because of the narrow avenues of adjudication, where to go, how to make it work, and the opposability before fora is very limited. Thank you.
Thanks so much. So there were two participants who had questions. Jens, I think you were first. And Eugenio.
Thank you. Thank you. My question is also about strategic legislation, strategic litigation, and it somehow continues from where Tamás just ended. The EU is also not a party to the European Convention on Human Rights, of course. So therefore, the EU as such cannot be brought before the Strasbourg Court of Human Rights, but member states can. And although we have discussed a number of weaknesses in the European Court of Human Rights approach to sort of scrutinizing border control or border measures in recent years, they have sometimes been better than that, as we also discussed. And as one example, actually, the Strasbourg Court has, at least on a couple of occasions, been quite firm in sort of pointing to patterns of refusals to receive applications for asylum by the Polish border guards. So there seems to be a kind of more or less well-established culture of disobedience or bad faith conduct by the Polish border guards, which might, by the way, also explain some of the occurrences concerning some of those fleeing Ukraine, which we discussed this morning. And I'm just wondering whether this could be maybe inform some potential measures for litigation. So I have one question to Cecilia and one to Tamás. Cecilia, have there been attempts that you may share with us to submit complaints against member states for on the basis of the evidence provided by the protection of rights at borders? I'm aware, of course, that you need to exhaust domestic remedies, but in case member states are not conducting any effective investigations, that might in itself be a cause for Strasbourg litigation, which might then also exempt more or less perhaps from further domestic remedies, so to say. And my question to you, Tamás, is could you think of supporting evidence in addition to that provided by individual victims and by NGOs such as Protection of Rights at Borders? Could there be other kinds of supporting evidence from monitoring bodies that might be sort of facilitating this kind of scrutiny by the Strasbourg Court of Human Rights? We already know that the Strasbourg Court is absolutely willing to base its assessments on evidence from Council of Europe bodies, in particular the CPT, Committee for the Prevention of Torture, to some extent also ECRI on discrimination issues. So I'm just curious to know whether you could think of such supportive evidence that could be helpful in such potential litigation cases. Thank you.
Thank you, Jens. Yeah.
Thank you very much. My name is Emilia Vartanova, PhD candidate at Lund University, Sweden. I also work in the area of complementary pathways, and I tend to be critical of the process of their cooptation by containment. So in that respect, I was interested in both your positions, Eugenio and Inma, which also sound like they're very critical of complementary pathways. And I very much like the metaphor of complementary pathways being seen as a smokescreen. So if you allow me, I would like to use it in the future. But I'm also interested in what Inma said more concretely, that what we want is safe and legal channels and not so much complementary pathways. This is how I understood it, at least. If this is a solution that basically contributes to containment. So I wanted to ask you if my understanding of your words is correct, and if it is not complementary pathways that we want. So basically that would mean that complementary pathways do not have the potential to provide the necessary level of protection for people in need of international protection. Then what is it that we want? Thank you.
Thank you. So there is a couple of participants who have raised questions. Thank you for that in the YouTube. The first one relates to the issue of double standards between Ukrainian nationals and non-Ukrainian nationals that was mentioned. Particularly for Eugenio, if you could develop a little bit more on that point, and of course, any other colleague who would like to develop on that point, the fact that the temporary protection activation leaves the option to member countries to provide parallel protection regimes, not the temporary protection status, but parallel national regimes, and therefore are by design excluded from the personal scope. If you could develop on this double standards issue. There is another participant who mentions the issue of resettlement in Sweden with the new government, announcing the annual refugee resettlement quotas to be reduced to about 900. The participant raises, how can we make legal pathways more stable, which perhaps raises the question of non-legally binding resettlement options and questions of legality, of binding or not binding nature of those instruments. So perhaps Cecilia would like to later to develop, or other colleagues would like to develop on that. And with this, we will close to see how we go, but take it also as perhaps all the speakers as your perhaps last chance before we close the meeting, as your final statement also. So responding to the questions, but also as your final statement as well. Eugenio, would you like to start?
Thank you. And I also take advantage to make a couple of comments on some of the things that have been said before, also by some of the other panelists. First, and of course, all this comes from someone that is not neither an academic or practicing lawyer. It's a practitioner, let's say. I found it very interesting, the explanation of the various remedies that are available within the EU law and the EU treaty for violation of human rights. But I do wonder who of either the family or the individual in Libya that have suffered violation of human rights because of policy that are put in place and paid by the EU has actually ever used those mechanisms. Because the point is not whether we have a fantastic law written down that explains all the options that someone might have to get redress. The point is how accessible those redresses are. This is a fundamental principle when it comes to access to justice. You have a lot of places where in writing you have possibility of family reunification, that the actual practice to get somebody in a given country for family reunification, if it's not impossible, it's close to it. A lot of country, this one, my own country, Italy, has in theory legal migration pathways. The fact is, it's almost impossible for anybody to access those pathways. So one thing is what you have in writing, and one thing is how actually available in practice is. I don't think anybody, I haven't, by the way, and I have a degree in law, but I don't think anybody in the Libya Detention Center has read the EUTF. So they're not going to know that there is this option, even if, and if these options were really available in practice, then we would, I wonder how come that the policy remains the same or actually gets worse. That there would have been a flurry of redress sought. So I think the issue here is legislation is a tool to implement a vision or a policy. Is whether the policy goes in a certain direction and then you have law that creates the tools to implement that vision. Is not the other way around. And this is proven by the fact that with a vision that goes more and more towards containment, we have a proliferation of instruments, including legal instruments and agreements, bilateral or otherwise, on externalization. So what we need to look at is the policy, and what we need to try to implement is the policy, because that's what makes changes, I think. And yes, on how much politicians right now are keen to look at evidence, I remain skeptical, and maybe it's my own personal frustration. But I remember during the negotiation of the Valletta Declaration and the Plan of Action, where there was a friction between EU member states and African member states on certain issues, specifically regarding return. And one EU delegate of one EU country told me, oh, the Africans have to understand that they have to accept our view, otherwise we are going to be flooded in Europe with extreme right-wing governments. Well, guess what? The African accepted that view, and here we go, having a flurry of right-wing government in Europe anyway. So the way politicians look at evidence, it's questionable in my view. That's why I said I think there are other avenues, public, the press, academic world. There are other spheres where evidence can be used and hopefully make an impact on the public opinion, that will hopefully make an impact on government. On the double standard, there is not much to say, in the sense that this is, I think, another double standard in the Ukrainian response. It's another demonstration of the way the EU looks at migratory flow in general, including refugee flow. And I'm sorry to be maybe blunt and politically incorrect. This is Chatham House, right? Somehow, this meeting, to some extent, it's not Chatham House? No. Okay, then I will need another job afterwards. The fact is that EU member states have decided to apply the TPD this time for the first time, while they refused it before. And we requested, I think you, a lot of other people, asked the EU to apply the TPD in 2015, not even an answer, because you have a group of A, European, B, white, and C, non-Muslim people arriving. That is a fact, because every time there is a different group of people arriving, this issue is not even looked at. So I don't know if there is more to elaborate. This is why I said the use and what has been done, luckily for the Ukrainian, is the exception that confirms the rule. You have a sort of group of people that are considered more. There is a country, talking about resettlement, a European country years ago came to IOM and asked if we could help them resettle people from Syria, but only Christians.
Oh, yeah.
So, and last thing, and then I really shut up, on complementary pathways. Yes, I think more than complementary pathway, we need the legal channel or legal pathways or legal, whatever you want to call it, to allow people to move in a safe, dignified way. Let's not forget, since we talk about violation of human rights, trafficking, and also smuggling is a criminal activities that involve migrants and or asylum seeker. It exists because of two reasons: the absence of legal way to arrive, and the fact that those who arrive irregularly, while governments are shouting against the irregular arrival, large sector of the economic setup of country receiving irregular migrants actually use irregular migrants workforce in the black market, sustain their sector with irregular migrants work, and are very happy that that happens. And there is a directive of the EU against this, which nobody ever talks about. Nobody applies, nobody refers to. We are content to combat trafficking by arresting a couple of traffickers on a flimsy boat that we stopped in the Mediterranean. Now I stop also.
Thanks, Eugenio. We are running out of time, so I would like to ask the speakers just to really a short concluding comment. It's not possible to have very in-depth answers. Starting with Inma.
I can do very fast. So on the complementary pathways and legal safe channels, I mean, she said it like the theoretical, the way to go will be with the proper safe and legal channels that he was saying. And the complementary ways should not be the way. But now, again, what I was trying to say is that in our humanitarian perspective of trying to find specific solutions for the people that we are seeing today in the detention centers that cannot go through the existing channels of IOM and UNHCR, if we can find solutions for them, we will go for that. Now, for the time being, we are doing so and we are collaborating. So we are referring people through UNHCR. I mean, that UNHCR takes them and then they put them in the humanitarian corridor with San Egidio. We do also in parallel ourselves with the embassies for humanitarian visas and so on. Now, and we are trying to do more humanitarian corridors. Now, depending on what they are going to validate in the EU before the end of the year and how this is going to put in what impossible package of things completely that can be horrible if you hear what they are discussing at the council with the instrumentalization package and all this, maybe we will have to say how maybe to try to do it, I don't know, bilaterally without those corridors formally as maybe they put us in an impossible situation. But we will try. I mean, what we try as a humanitarian organization is that people don't die in our hands. So we will try and yes, in that sense, yes. Then on the maybe the conclusion on the evidence. So yeah, but I leave it like that because it has been said all. Yeah.
Thank you so much. Tamás.
Thanks, Sergio. Thanks for the questions. First, very telegraphically, Jens, yes, I do consider positively supporting evidence by other monitoring bodies than Council of Europe entities to Strasbourg court proceedings. Recently, FRA materials have also been referred to by the court. So out of the Council of Europe, an EU entity like our agency has been considered as reliable evidence provider in 2 cases at least. Also in a recent case against Croatia, you know, this unfortunate death of little Madina when the lady, this young girl was hit by the train. It was also Amnesty International material referred to. So I can see like an opening of the court welcoming more evidence than just coming from Council of Europe bodies. The second question regarding the double standard, I mean, between the treatment of people fleeing the war in Ukraine and other people. I mean, it's like it's clearly there. Just think of what's happening at the Polish-Belarusian border still, or the Hungarian escorting back policy via the fence at the Serbian border continues. So I mean, it's everyone who is fleeing a war or a conflict should be welcomed, and their claim for international protection needs to be examined irrespective of nationality, ethnicity, or the country of origin. So it's clear. And here again, another piece of shameless self-promotion for the agency. Tomorrow, our second bulletin on Ukraine, more specifically the migration-related fundamental rights implications of the war in Ukraine, will come out. So you might look into that for further reflections on this double standard as well.
Thank you. Thank you. Cecilia.
Thank you very much. Just maybe to say a little bit about the remedies that have been mentioned here that are available to people. And I think from our side, the importance of having available legal aid within humanitarian responses, I think is an important part of that people cannot access the remedies on their own. And that's obviously part of it. And for Jens on specifically on the PrAP project in courts, DRC is not alone in this project. Obviously, it's a consortium of many partners, and information there has been used in several courts. On legal pathways, there's a question on Sweden, and I think it's a sad journey that Denmark took a couple of years ago as well. And I think it's important to discuss other legal pathways now that resettlements are shrinking spaces now in Sweden, but it's also clear that it's too discretionary for states to be a really good alternative to, for example, resettlement. And so I think what Inma spoke to about safe channels, I think that is really key, that people are able to access territory without their lives being in danger. And then I think just maybe to end off with information on the consequences, and it's not only on evidence, but also actually to be sure that people who experience these consequences, and I think I've said it already, but I will repeat it again, that they are actually, that we and others engage with people when it comes to the effects of these measures, so that it is not just the humanitarian community and others, but also people who actually live the consequences, that are able to point to where the challenges are. It may be very obvious in prisons in Libya, maybe a little bit less obvious in other situations where it's more blurred and where responsibility may also be very blurred, but that people are part of the solutions to their own situation. I'll end with that. Thank you.
Thank you, Cecilia. Well, this has been a fascinating panel and set of presentations and conversation and debate, which was really a wonderful end to the training school, ASILE training school. All these days we've been together. Certainly elements that will continue informing the work that we are doing in the project relate to questions of circumvention of the law and questions of responsibility and accountability. We even touched upon issue of evidence and how evidence can contribute to accountability and responsibility uptaken and relocating responsibility where it comes from. And I really hope, well, first of all, I would like to thank all the speakers and all the participants here and those who are joining us in YouTube electronically also for your questions and your participation. But more widely, thanking all the participants of the training school of ASILE for their amazing papers and exchanges and presentations and participation. My colleagues here at MPC, Migration Policy Center, for the logistics, together with SEPS, Miriam Mir, also, who have made all this possible. And we'll be in touch in the sense of follow-up activities within the project, the ASILE project. Yeah, really big thanks. Also, personally, I enjoyed it very much. So, yeah, thank you.